Hello everyone, I am Miss Priyanka Sanjay Late, working as lecturer at Mula Education Society's Mula Rural Institute of Pharmacy Sone. In this presentation, I am going to discuss topic that is forms of business organization. We will discuss content of presentation, definitions of partnership and partnership date, characteristics, silent features, advantages and disadvantages of partnership, kinds of partners, kinds of partnership, joint stock company, silent features, advantages and disadvantages of joint stock company, kinds of companies and comparison between joint stock company and partnership firm. Firstly, we will discuss definitions of partnership. According to Section 4 of the Partnership Act 1932 defines partnership as the persons who have entered into partnership are individually known as partners and collectively as a partnership. The business organization runs as a partnership is called a firm. The Indian Partnership Act defines partnership as a relation between persons who have agreed to share the profits of a business carried on by all or any of them acting for all. The next definition, partnership deed. It is a written agreement which contains terms and conditions as to be relationship of the partners among each others. The following conditions terms be included in that: first, amount of capital to be invested, how profits and losses should be shared, amount of drawings allowed, interest on capital, interest on drawing, salary agreements. Characteristics of partnership. Partnership is a voluntary registration, continuity in a partnership business, contractual relationship included in partnership business, transfer of interest, mutual agency, sharing of profits and loss to other partners, unlimited liability in partnership, and membership included in a partnership business. Next point, silent features of partnership. In partnership business organization, two or more persons up to a maximum of 20, 10 in case of banking firm, join together to share any profit made by the firm. Second, partnership is formed on the basis of an agreement between the concerned person. The partnership agreement may be oral, written, or implied between the persons joining together in the partnership. The document containing the agreement is called the partnership deed. Third, any profit made by the partnership must be distributed among the partners in the agreed ratio, usually in proportion to the amount of capital invested by each partners in the firm. If and when a partnership is dissolved, the firm does not, however, necessarily stand. Dissolve it depends on the remaining partners whether to continue the firm. However, the dissolution of firms takes place in the following circumstance. First, if the partners agree that the firm be dissolved. Second, in the event of all the partners becoming insolvent. Third, if the business becomes illegal. And fourth, in case the court issue orders that the firm be dissolved. Fourth, a partner cannot transfer his share to an outsider without the consent of the other partner. Next point, advantages of partnership. First, a partnership is quite easily formed. Any two or more legally competent persons may start a business on partnership basis after executing an agreement between them, which may be oral, written, or implied. Second, Decision to start a partnership organization is quite prompt since partners can meet as and when needed. Third, partners may pool their individual resources to collect enough finance for smooth running of the business and also for its expansion as and when required. Fourth, since there is an unlimited liability of the partners, it serves as an important security to creditors who lends money to the firm. Next point, disadvantages. In that first, it has been seen that in certain cases it is difficult to maintain mutual understanding and harmony among the partners after the firm has worked for some time. Second, there is lack of stability in the business. Death, insolvency or retirement of a partner may result in dissolution of the partnership. Third, a large scale business cannot generally be run on partnership basis because of the legal ceiling on the number of partners and also due to limited resources of the partners. Fourth, partners bears an unlimited liability for the debts of the firm. Business creditors can recover their dues from all or any of the partners. Fifth, a dishonest or incompetent partners may land the firm in difficulties because his acts will also bind the firm and remaining partners. Next point, kinds of partners. There are 7 kinds of partners. First, active partner. Second, inactive partner. Third, nominal partner. Fourth, partners in profit only. Fifth, secret partner. Sixth, minor partner. And 7, partner by estoppel. We will discuss one by one. Let us see. First, active partner is also called as a working partner. He takes an active part in the management of the firm business and bears an unlimited liability for the debits of the firm. Like other partners and active partners also contribute capital to the firm. Second, sleeping partner is also called as a inactive partner. A sleeping partner does not take any active part in the management of the firm's business. He, however, contributes capital and shares the profit losses of the firm. His liability for the debits of the firm is unlimited. Third, nominal partner. In that, he only lends his name to the firm as a partner. He, however, neither invests any capital nor claims any share in the profit of the business. Through he does not take any part in the management of the firm's business. He bears unlimited liability for the debits incurred by the firm. Fourth, partners in profit only. He invests his capital only with a view to earn a share in profits of the firm and has no liability as regards to any losses suffered by the firm. His liability for the firm's debits is, however, unlimited. Next, fifth, secret partner. A partner who does not want the fact of his being a partner be known to outsiders is known as a secret partner. However, his liability for the firm's debit is unlimited. 6. Minor partner. A partner below the age of 18, being a minor, does not enjoy the rights of full-fledged partner in the partnership firm, since in a law he is not compelled to contract. However, the Indian Partnership Act allows a minor to be admitted as a partner provided all the other partners agree to it. A minor as a partner is entitled to a share in the profits and property of the firm. His liability for the firm's debits is, however, limited in proportion to his share in the profits and property of the firm. On attaining majority, a minor partner has a choice to continue as a partner or not. If he does not give a public notice of his choice within 6 months, he will be treated as having decided to continue as a partner. After becoming a partner, a firm his liability will become unlimited. WEF, the date of his original admission to be the partnership. 7. Partners by estoppels. If an outsider behaves in such a fashion that he is mistaken as partner of the firms by third party, he will be held liable to all those third parties who extend credit to the firm on the assumption of his being a partner. Such a person known as partner by estoppels, because of his having behaved as a partner, he cannot deny the liabilities attaching to the position of a partner. In actual practice, a partner by estoppels is not a partner of the firm. He neither contributes any capital nor takes part in the management of the firm. Next point, kinds of partnership. From the point of view of liability of partners, a partnership may be of two types, namely general partnership and limited partnership. General partnership is divided into three types: partnership at will, particular partnership, and third, joint ventures. In that first, general partnership. In a general partnership, the liability of every partner is unlimited. In case the assets of the firm are not sufficient to pay off its liabilities, even the private property of the partners may be used to meet the undischarged liabilities. However, a minor partner is an expectation because his liability for the firm's obligations is limited to the proportion of his shares of profits and the capital. Each partner of a general partnership is entitled to participate in the management of the business unless the partners themselves decide otherwise. In that first, the partnership at will means the agreement to carry on business without specifying any time. Second, particular partnership, it means the agreement to carry on business for fixed period or fixed ventures. And third, joint ventures, it is an agreement for completing a specific task or project during a fixed period with contributions of capital and sharing of profit and loss. Second type, limited partnership. The unlimited liability of partners is in general partnership discourage investment of large sum in the firm. The limited partnership is a way out of this difficulty, although it is not permitted under the Indian law. Such a partnership is found in UK and USA. The main features of such a partnership are: in that first, a limited partnership consists of two classes of partners, namely general partners and special or limited partners. In general partners with unlimited liability and special or limited partners with their liability is limited to their capital contribution. Second, a limited partner simply invests his money in the firm through he is not entitled to take a part in the management of the business. He is allowed to inspect the books of the firm for his information. Third, the death, lunacy, or bankruptcy of a limited partners will not affect the existence of the firm in any way. As such, a limited partnership is more stable than a general partnership firm. Fourth, a special partner cannot withdraw any part of the capital contributed by him. If he does not, so his liability on the position, so withdraw becomes unlimited. Fifth, a special partner cannot assign his share to an outsider without the consent of the general partners. Next point, joint stock company. A company is governed by the Company Act 1956. It has to follow various provisions of Act. Hence, the company form of organization has to comply with various statutory requirements. The growing needs of modern industry and commerce could not be met by sole proprietorship or partnership. A joint stock company is a better method of mobilizing financial resources. A joint stock company is organized to carry on a business on large scale because its capital requirement and risk obligations are too burdensome for a single individual or for a few individuals to bear themselves. Next point, silent features of joint stock company. First, a company is an incorporated association. It comes into existence only after registration under the Company Act 1956. Second, the members or shareholders are the owners of the company. The business is run by the board of directors elected by members in the general body meeting of the company. Third, the capital requirement in the business is divided into shares of small denominations so that would-be investor can visit a small or large sum of money as they desire. Fourth, the shareholders is always free to withdraw from the membership of a company by transferring his shares. Next point, advantages of joint stock company. The liability of the members of company is limited to the nominal value of the shares held by them. Second, the risk for each member is reduced because it is diffused and spread over several members of the company. Third, a company pays income tax at flat rates. This means on higher profits it will have to bear lower tax liability as compared to other. Fourth, the joint stock company enjoys perpetual successions, insolvency, insanity, or death of its members has no effect on the existence of the company. Next, disadvantages of joint stock company. In that first, the formation of a company is costly and time-consuming process. There are a number of formalities which are required to be complete with. Second, the company cannot take promote decision because of the time lag between board meeting and the difficulty of getting the requisite quorum. Third, it is not difficult for an unscrupulous management to induce in malpractice. Sometimes bogus companies are floated to cheat the investors of their hard-earned money. Fourth, the secrecy of the business affairs cannot be maintained because every issue is discussed in the meeting of board directors. The minutes of meeting and accounts of the firm has to be notified. Fifth, a person controlling a company have large-scale financial resources at their disposal. They may attempt to influence the economic and political decisions made by the government. Next point, kinds of companies. Companies may be classified from the four different point of view. In that, first, from the point of view of incorporation. Second, from the point of view of liability. Third, from the point of view of nationality. And fourth, from the point of view of public interest. In that, first, from the point of view of incorporation. In that, first, companies incorporated under a special chapter. These types of company does not exist in India. Second, companies established by a special act of parliament. These companies are also called statutory company. Third, companies incorporated under the provisions of Company Act. These companies are also called a registered company. Second, from the point of view of liability. In that, first, companies with unlimited liabilities. Second, companies with liability limited by guarantee. Third, companies with liability limited by shares. Third, from the point of view of nationality. In that, first, national companies, that is, those companies operate within the boundary of the country of registration. Second, multinational, that is the companies which operate in various parts of the world. And fourth, from the point of view of public interest. In that, first, private company. Second, public company. And third, government company. In that, first, private company, a company which is run by a minimum of 2 members or by maximum of 50 members, does not allow public subscription to its shares, and it also restricts the transfers of its shares, is called a private company. A private company combines in itself the advantages of limited liability with the facilities of the partnership organization. For this reason, it is preferred by many businessmen. At the same time, a private company is not as suitable a form of business organization as a partnership because the firm will have to pay higher income tax as compared to the partnership organization. Moreover, the goodwill of the firm will be adversely affected by the limited liabilities of its partners. The title may be given in private company, that is XYZ Private Limited. Second, public company. A company can be formed by a minimum of 7 persons having no maximum limit on its members, offers its shares to the public with a view to collect large sum of money to finance its projects, and also does not restrict the rights of its members to transfer their shares preferably. Such a company is called public company. Title may be given in public company, that is ABC Limited. Third, government company. A company is called a government company if at least 51% of its shares capital is held by a central government, a state government, or jointly by the central government and state government. Next point, comparison between joint stock company and partnership firm. In that first joint stock company, the company is formed by registration under the Company Act 1956, and in partnership firms, the partnership firm is formed by agreement among partners. Second, in joint stock company, the registration of the company, and in partnership firm, the registration of the firms is voluntary. Third, in joint stock company, the shares of the company can be transferable, and in partnership firm, a partner cannot transfer his share to an outsider without the consent of the other partners. Fourth, of joint stock company, the company is managed by board of directors, and in partnership firms, the firms is managed by the partners. Thank you.